just want to say that I'm delighted to be here, to be part of your IT book series. Here at Chicago Kent, you have a really deep well of law professors and others who know a lot about law and technology. In addition to Professor Lee, you've had many contributions in First Amendment and in the relationship between innovation and IP. It's a fantastic resource. You have Richard Warner, who was kind enough to come, who's active in the privacy scholarship field, and I get to see him every year. Lori Andrews teaches here, and she wrote a great book a few years ago about social networking and what it means to document your life so carefully. And you even have Elizabeth de Armand, who is someone I've followed for a long time because she is a deep expert in the Fair Credit Reporting Act. And she even writes a treatise about the law, and that's a really important law. It's an old privacy law in the United States, and it's basically the one that protects you from companies that use data for in the job, and the tenancy, and the credit context. And it's kind of our first line of defense against credit discrimination in the US. So you have this deep well of people, and so I'm delighted to be here and talk about my book, Federal Trade Commission, Privacy Law and Policy. This is a big book. There's a lot in it. So I really struggled to figure out what I should talk about in just 25 minutes, and I'm going to go quickly so I can cover these issues. So I want to talk a little bit about why and how did the Federal Trade Commission become so powerful? And then instead of giving a long lecture about what Federal Trade Commission privacy is, which I spent a whole semester teaching at Berkeley, I'm going to give an overview of some of the tensions that have arisen at the Federal Trade Commission concerning privacy. And then finally, I thought it'd be fun to talk a little bit about the Trump administration and what the Trump administration might mean for the FTC. We know a little bit about that, not so much yet. Along the way, maybe we can touch on some theoretical considerations, perhaps in the Q&A. My book is a critique of public choice theory, and it's also about the rise of the administrative state and new forms of regulation. And so that's where most of the theoretical contribution is. And then finally, a great question, if you're a student or if you're interested in privacy law and you're thinking about things to write about, well, one thing you could write about is whether it makes sense for the Federal Trade Commission to base its privacy law in its advertising law precedents. So basically what you'll see in my presentation in the book is that the modern Federal Trade Commission privacy law is basically just advertising law. It's the law of advertising applied to new technology. Does this make sense? Now, I've never seen anyone really tackle that issue. And I tee it up in my book, but I don't answer it. So how did the Federal Trade Commission become so powerful? Well, the Federal Trade Commission is a century-old institution. It was created not to protect consumers, but rather to deal with the problem of monopoly and trust at the turn of the century. So some of the problems that existed included that single companies were in charge of most of consumer lives. Most steel in the United States was made by a single company. When you bought goods such as sugar or flour, these were basically these goods that you needed to operate your household were sold by trusts who could control prices. And they could engage in a whole series of problematic business activities. But it was difficult to say exactly why these activities were problematic. So Congress reacted to this by creating the Federal Trade Commission to regulate these different types of trade as unfair or deceptive, but without explicitly defining what was unfair and deceptive. So it's difficult to tie all these problems together. So Congress dealt with this by saying, okay, what we're going to do is we're going to create this agency of experts that's going to decide when product tying and local price cutting is unfair or deceptive, because they couldn't prospectively regulate it. One of the reasons why this came about is that existing consumer protection at the time was based on the common law, and the common law tools were ineffective for protecting consumers. So at the common law, you could remedy rip-offs and false advertising, but you as the plaintiff had to prove that you were harmed. You had to prove that the seller specifically misled you, and your remedy was limited to the extent to which you were misled and that you relied on those misrepresentations. So there were a lot of hoops for plaintiffs, and this basically didn't work. That you couldn't get a remedy for large-scale frauds. And then we had a crisis in enforcement based in part upon the idea that the economy became more complex. You have the rise of manufacturing. You have the problem where the consumer buying a product is buying it from a middleman who, and thus is not in privity with the creator of the product, etc. So a more complex environment in commerce triggers a realization that the common law tools are just not working. Let me note one thing that's really interesting here. The common law dealt with public frauds, such as let's say you were a seller of sugar, and you realized you could make 5% more by altering your scale, so that you're selling people 15 ounces instead of 16 ounces of sugar. That type of deception is very difficult to detect, and as a result, the common law dealt with that as a public fraud and charged it criminally. Okay, so this is kind of the world we're in at the turn of the century, and I'm going to return to this at the end of the presentation. And I'm not sure why, but my image here isn't loading. So at the same time as the Federal Trade Commission was created, we had the what I call first wave consumer protection. Much of it is triggered by problems such as the patent medicine industry. Patent medicines are confusing because they use the word patent, but really these were medicines that were protected by trade secret. Many of them were simply alcohol or opioids. And so there are many cases of children and other people dying or becoming addicted to opioid medicines during this period. How do you deal with it? Congress says, well, what we're going to have is the 1906 Pure Food and Drug Act, and what we're going to do is we're going to label these products. We're going to say this product contains this or that. We also see, and I'm not sure why my image isn't showing up here, we also see the rise of very stringent self-regulation in advertising. So think about the turn of the century. What's happening is the first advertising agencies are forming, and they want advertising to be a profession. But when they look around, and if you look at turn of the century advertising, you see that tons of it is deceptive. It's just completely fraudulent. So advertisers get together and they enact something called the Printer's Ink Statute. It gets enacted in almost all 50 states, and it creates criminal liability, strict liability, and criminal liability for false advertising. Okay, so this is how intense the reaction is to patent medicines and the like. Ultimately, it was a failure, and the reason why is that prosecutors were unwilling to bring criminal actions against people for false advertising. Just weren't willing to do it. Okay, so it ultimately doesn't work, but a lot of those laws are still on the books in the United States. So what we have eventually is the Federal Trade Commission Act, and it comes about as a compromise. And the interesting thing about the compromise is that the result was not what kind of anyone foresaw. You have the Republican Party that wanted a body that looks much like the current FTC looks like. It would be an adjudicatory body. The idea would be if businesses had problems, they could go to the Federal Trade Commission and get very quick remedy. They'd stay out of the federal courts. So it would be due process light, okay? It'd be a fast-moving body to solve business disputes. The Democrats, and bear in mind this is when the Democratic and Republican parties are switching their orientation, so it's not immediately intuitive. But the Democrats wanted a weaker entity that was mainly information that could do investigations and take the information and give it to Congress. But what happens between the House and Senate and between these different parties is they pass a super agency law, a law that is much stronger than many anticipated, a law that gave the FTC inquisitorial power. So the FTC could just kind of investigate any industry they wanted. They could force information and so on. They could do all these different things. So there's a fantastic quote by Learned Hand at the time when the FTC Act passes. It basically says there's nothing in history like the FTC, not the ICC, not the emerging FDA. The FTC was the most radical creation of its time. We have a second wave of consumerism that begins in the 1920s and 1930s, and what the image of is of a product called Marmola, and it's fat. It's an ad for a product that melts fat. And what it actually is thyroid glands. It's desiccated thyroid glands. It's actually dangerous to take. The Federal Trade Commission sues this company saying, you can't introduce this product in the marketplace, it's too dangerous, people are gonna die from it. And the Supreme Court says, no, Federal Trade Commission, you cannot bring this case. Because under your organic statute, you're supposed to be policing monopolies and trusts, not doing consumer protection. So the case gets, Marmola is let off the hook. This creates kind of chaos for consumer protection. And in the 1930s, there is rabble-rousing around creating new protections for consumers. There's a huge contest between the FDA and the FTC about who is going to regulate advertising and consumer protection. But ultimately what happens is Congress passes a law that gives the Federal Trade Commission the power to prevent companies, partnerships, persons, and so on from using unfair methods of competition and unfair or deceptive acts or practices. So this last clause here gives the Federal Trade Commission the authority to police actual business practices. And so the FDA, so that Congress decides that the FTC is going to have this power, not the FDA. And so this was a significant expansion of its power. Okay, so not much happens at the Federal Trade Commission in the 19th. So despite the fact they get this fantastic power in 1938, not much happens in the 40s and 50s. And then there's this key breaking point at the FTC. The Surgeon General's report on smoking and health comes out, and it's released on a Saturday. Anybody know why? Government releases a report on a Saturday? Anyone want to guess? Just yell it out.
Nobody would read it.
They were actually afraid too many people would read it. Any other? They thought it would crash the stock market. Okay? Because this report says definitively smoking causes cancer, right? And millions of Americans are dying because of cigarette smoking, and it's about time the government do something about it. So this is a fantastic episode in FTC history. On Saturday morning when this report comes out, all 5 commissioners go to the office, sit down, and they read the report while they're smoking. And when Chairman Dixon, who was the chairman of the FTC for 20 years, finishes reading this report, he puts out his cigar and he says, "That's it. I'm not smoking anymore." That's how revolutionary the report was and how convincing it was. And so the FTC very quickly reacts. They feel, Dixon felt that he was under a kind of personal obligation to protect his own children from taking up smoking. And so very quickly, just within a matter of weeks, the FTC puts out a statement saying, we think it's going to be an unfair practice for a cigarette company to market a tobacco product unless it contains this warning. cigarette smoking is dangerous to your health and may cause death from cancer and other diseases. Death. Do you remember this warning? Anybody remember this? Any former smokers? Anybody willing to admit it? Well, one of the reasons why you don't remember this this warning, and let me just as a point of order say, please get pizza. I will be fine. Let me also mention that this warning was drafted by Richard Posner, Judge Richard Posner. Okay, Congress intervenes, and it says, you are not putting that warning on cigarettes. And instead, Congress passed a law saying that the warning has to be cigarette smoking may be hazardous to your health. And it's interesting because they watered down the warning. They passed a law saying the FTC couldn't put in a more stringent warning. And it's among several examples of the FTC being punished for being too aggressive, too pro-consumer. And this is one of the first points I want to make about public choice theory. Public choice theory would predict that agencies like the Federal Trade Commission would be captured by industries, and that it wouldn't do things such as regulate tobacco. But the Federal Trade Commission very aggressively went after tobacco. It was the only DC institution that was willing to. The President, Congress, the other agencies all fought the FTC. And one of the things that's interesting about this incident is that when you look at performance of industries in the United States over the last century, tobacco is the most successful industry, period, in the United States. Second to none, to quote our president. It's hard to imagine the FTC as a captured entity when it is willing to go after such a powerful actor in the economy. The other example where the Federal Trade Commission overstepped its bounds and was punished by Congress for it is the kid bid controversy. You might have heard about this here and there. And one of the, what my book does in this context is it goes back through the history of kid bid, and it points out that it was started by Republicans. It was the kid bid issue, and this is advertising to children, was actually a Republican initiative led by President Nixon's chairman of the FTC. The agency was concerned that advertisers were controlling the thought of children and getting them to buy too much sugary food. And their concern, interestingly, was not obesity, it was tooth decay. And if you go back and look in context, in fact, a huge number of children have 3 or 4 cavities by the time they're 8 or 9 years old. So the FTC started to say, the problem is this advertising for frosted flakes and whatnot. We got to do something about this. And so the FTC started by trying to get the groups to self-regulate. They wouldn't. They established this incredible record, which included all sorts of damning quotes from the advertising industry, including one of my favorites. It actually comes out of an advertising textbook. When you sell a kid on your product, if you can't get it, he will throw himself on the floor, stamp his feet, and cry. You can't get a reaction out like that out of an adult. So the FTC built this record saying, we really got to do something about the advertising industry. And then they invited comment on a rule that would ban all advertising on programming directed to kids under 8 years of age. Wow, right? That is something. And then there were other rules. And this wasn't exactly a proposal. They wanted comment on such a rule. But this caused the advertising agency to go berserk. They went hardcore after the agency. At the same time, President Reagan is elected. They shut down the FTC twice. It more or less permanently injured the ability of the FTC to get appropriations. authorization and appropriation has been a continued problem for the agency. Congress banned the FTC from any advertising action for 2 years. Can you imagine that? Can you imagine going to the Department of Justice and say, don't enforce any violations of this law for 2 years? It's just kind of unheard of. But this is how powerful and how angry the advertisers were. And what this causes is the Federal Trade Commission retreats from using its unfairness power. It switches, it starts using its power to prevent deceptive trade practices, and it moves to enforcement rather than to rulemaking. So with that kind of background, we have the privacy cases start, and they start in the FTC actually started its internet cases in the 1990s. I think the first case was 1992. Pretty early in the history of the internet, the FTC was involved. And what happens is, as the FTC takes on privacy cases, all sorts of new tensions arise. And these tensions are similar to the problems that the FTC experienced with tobacco and with KidBit. They had to say things like, they had to move to using experts more often. They are trying to push a series of standards that evolve with time rather than specific rules and so on. And so what we see today is that there are all these important privacy problems that are causing political blowback and sometimes litigation against the agency. So amongst the privacy problems that the Federal Trade Commission is having is how to identify the types of omissions in privacy policies that are important enough to police. So in the 70s, the FTC went after companies that did things like tax preparation. And they do your taxes, and they'd never tell you that they were taking all the information off your tax return and selling it to advertisers. Another example is in the survey industry. So there are companies out there that are surveying customers all the time. And they are, one, lying about the fact that the surveys are anonymous. They're actually using complex coding to figure out who is actually filling out the survey. And then they are linking that information and selling it to advertisers. So in as early as the 1970s, the FTC begins to say, these types of omissions are serious enough that we think they're unfair or deceptive. And so fast forward to today, the questions around privacy policies are, you have this long privacy policy that might be 10 pages long, and it still might omit some critical fact. It might say something like, we target advertising to you in an anonymous way, but they might omit the fact that they're using a company like Axiom or Experian or the like to figure out who you are, to buy data about you that you are not providing. So is that omission serious enough for the FTC to take action? It's one of the basic problems that currently exist. Another concerns the responsibilities of intermediaries. What to do about the companies that make privacy invasions possible? So this is one of my favorite cases. It's a very early case from the 1950s. And it involves a company that created postcards for debt collectors. So if you were a debt collector, you would buy these postcards and you'd send them out to people. And the postcard says, friend, we have on hand a package, and we'll send it to you if you completely fill out the return card, giving sufficient identification to warrant our sending this package to you. That's kind of strange. And the information you're asked to fill out is like your height and weight and whether you're married and where you work, and references, people who know you and where they live. Well, this was deceptive and unfair information collection because it was sent to debtors to identify them and to collect their debts. And the FTC went after the company that actually printed these cards rather than the debt collectors that sent them out. Isn't that interesting? And so you could fast forward today and ask the question, what responsibilities does Visa or Mastercard have for fraud? Or companies that do electronic checks, or Facebook or Google or the like? What responsibilities should they have for fraud that is that occurs on their network? And so this is another area with a lot of controversy. Another space where there's a lot of heat is what to do about platforms. And this is the area where the Federal Trade Commission's antitrust and their consumer protection interests begin to merge. What to do about companies like Facebook, or Google, that say, we're going to bring about a revolution in advertising, we're never going to do X, Y, or Z. 10 years later, they're doing X, Y, and Z. And in fact, they're doing it far worse. Look at Google and YouTube, right? They have television commercials now that you can't skip. Okay, so it's actually worse than television, because you can't skip the ads, like let's say with a TiVo, and those ads track you. So the Google people came along saying, we're going to have this whole new system, and we're going to make advertising work in a way that works for consumers. But what they end up doing is just copying their competitors, sometimes doing it in worse fashion. So how do you deal with these type of companies that are essentially bait and switches? And I think, I argue in the book that Facebook, there's actually nothing innovative about Facebook. Okay, I'd love to have people argue with me about this. Tim Wu agrees with me. He says that Facebook wasn't very innovative. It was a marketing innovation. Facebook was a marketing innovation. And the things they promised, they went back on once they had sufficient network effects that you couldn't leave Facebook. So what to do about this? And I think what we have to start thinking about is whether privacy is enough and whether we need to use some type of antitrust approach to deal with companies like Facebook. Another tension in Federal Trade Commission cases surrounds expertise. So when you move to an administrative state system, when you move to a system of regulation where you're telling companies that you don't care how they comply with a law, you just want them to, you need experts to evaluate companies and their compliance, to figure out whether they're doing what they say they're doing. So what the Federal Trade Commission has done is they've hired short-term experts, experts who come in for short terms at the Federal Trade Commission. People like Princeton professor Ed Felton, Columbia's Tim Wu, Georgetown's Paul Ohm, my former student Ashkan Sultani, ACLU's Christopher Segoyan, and so on. These people come into the Federal Trade Commission for a year and help the agency understand how Facebook works and the vulnerabilities in these companies and so on. And so what do these people have in common? Any clue?
They're academics.
Academics, and these are Federal Trade Commission has hired the top people in the field. They've each one of these people they've hired is unquestionably an expert. Many of them, like Ashkan and Chris Segoyan, might be considered even white hat hackers. These are among the more aggressive technologists out there. They've exposed weaknesses in systems, etc. So this is a type of expertise you could decide to hire. You don't necessarily have to hire people like this, right? You could hire different people. And now what we have in the Federal Trade Commission, within the Bureau of Consumer Protection, there is an Office of Technology Research and Investigation. And it's led by a formidable person, Justin Brookman, former New York Assistant Attorney General. He ran the New York Attorney General's Internet office. So these are like high caliber people who are charged with looking at the Facebooks and the Googles of the world. This creates resentment, okay, amongst the business community, this type of expertise. They want different experts in. And then finally, what to do about insecurity. One of the things you learn quickly in privacy practice is that you have to have conversations with clients. Client says, I want to collect X. And your response is, okay, what are you going to do when you have a security breach and X is stolen from you? And they say, oh, we're going to have this, blah, blah, blah. No. You're going to have a security breach. All companies do. All companies have insecurities. You're going to lose X. What are you going to do? Are you sure you want to collect it? And so on. Well, this problem of insecurity is so broad and so problematic for us as consumers that it's caused a lot of resentment in the business community. So all companies have security breaches, and what happens when you have a security breach is you typically get a call from the Federal Trade Commission or from a state attorney general to suss out the breach. And then they listen to you, and they evaluate the strength of the security of your systems, whether you have reasonable systems in place and so on. And if they decide that your breach has interesting facts or might advance the power of the Federal Trade Commission, they might sue you, okay? And so in the business community, there's a lot of resentment about this. They feel as though they've been twice victimized. First by a hacker who broke into their system and stole X, and secondly by the Federal Trade Commission that comes along and sues them for having X stolen. And so what we see now is a whole series of pretty high caliber Chamber of Commerce backed lawsuits against the Federal Trade Commission in the security cases. And what's happening is, in these cases, Wyndham, which the FTC won, LabMD, which is currently being litigated in D-Link, what's happened is the Chamber of Commerce has argued that the Federal Trade Commission Act itself violates the due process requirements of the Constitution. Okay, because we don't have rules. We don't have rules saying what reasonable security is. It violates due process for the Federal Trade Commission to come along and to sue you for violating rules that don't exist. So we're in this weird place. If you spend time in DC, you'll see that the business community shows up in lobbies and they say, we don't want privacy rules, we don't want security rules. But when the Federal Trade Commission comes along and says, okay, you just changed everyone's privacy settings, or you just lost everyone's social security number, we're going to sue you, they say, oh, well, that violates our due process. And so this is the, anyways, you shouldn't be surprised about hypocrisy. It is normal. So third, and let me sum up with this. What's going to happen to the Federal Trade Commission in the President Trump era? And I realize that this is being recorded, and I might regret lots of this, and lots of it might be wrong, but I'm going to give it a shot. First of all, the Federal Trade Commission is an independent agency. There are no more than 3 commissioners from any party that run the agency. So for the past few years, there's been 3 Democrats and 2 Republicans. With President Trump, we're going to have 3 Republicans and 2 Democrats, probably. The real prize, however, is the chairmanship, because the chairman gets to hire the people who are in charge of case selection and case evaluation. They get to hire all the important staff. And what we're seeing is those important staff people are all retiring right now. The Bureau of Consumer Protection director just retired, and the Bureau of Competition director is just about to retire. So those people are gone, and now someone new is going to get to replace them. Well, what we see now is that our acting chairman, Maureen Olhausen, who's been on the commission for years, real institutionalist, really knows her stuff. She's a kind of middle-of-the-road conservative, is doing everything she can to show that she's a good actor and she can responsibly run the institution. I have no doubt about that. She could do a great job. But then what we have is former Commissioner Josh Wright, who's a professor at George Mason University. He kind of debuted to be the chairman. He's strongly supported by Google. And he's from the kind of Chicago school in the sense that they don't really have a big problem with monopolies. They think monopolies create efficiency for consumers, and it's kind of Google's go-to candidate. So you have Google lobbying for Wright, but what I hear is that he's not going to get a position because Steve Bannon hates neoliberals and neoliberalism. And Wright is a kind of committed neoliberalist. And so the current leading contender, as I understand it, is Utah's Attorney General Sean Reyes. Seems like he'd be fine. He's an Attorney General. He's got a good record. What I would worry about, though, is his connection to Utah. Utah and Florida are the states that have the biggest problems with consumer fraud. There's a whole town in Utah that it's notorious for Federal Trade Commission cases. St. George, check it out sometime. And so one's connection and one's political dependency on such entities could be really problematic in this role. I would never want a Florida Attorney General to run the Federal Trade Commission or a Utah Attorney General, just categorically, because of those states' problems with marketing fraud. And I'm happy to argue with people about that if you want to during the Q&A. Another issue that we're going to see in the Trump administration is what should the role of the economists at the agency be? The FTC has a whole division of economists that study antitrust issues, that study consumer protection issues, and currently at the FTC, the lawyers do case selection. So the lawyers have been selecting all these privacy cases, and those cases are evaluated by the economists. Well, the economists don't like this. Because what happens is the lawyers plead their cases, so the economists have no control, right? They take these cases and they say, well, we think this is deception. And as a result, the economists have no role in evaluating, in applying cost-benefit analysis, essentially, to the case. And so what we're going to see, I think, is under Olhausen or Commissioner Wright, we'll see the economists get more power. And they'll have more power in case selection rather than just case evaluation. I have a whole paper about this problem. I think we're going to see an increased role of cost-benefit analysis, and I put this book up here because it's a fantastic book, and it convinced me that cost-benefit analysis is a sensible way of doing regulation. It's totally fantastic. The problem at the Federal Trade Commission historically has been that whenever cost-benefit analysis is applied, it's almost always an excuse to get rid of consumer protection. They'll never say that the regulation meets cost-benefit analysis ever. So to me, it's kind of it's like playing on an unfair playing field. It doesn't make a lot of sense to have such a narrow version of cost-benefit analysis. And so key here is economists have, in the privacy world, economists have to look at transaction costs and the time of the consumer, but they're unwilling to do that. They treat consumers' time as being valueless. And as a result, it's very difficult to get any consumer protection through, or privacy consumer protection through cost-benefit analysis. Another area that we're going to have interesting problems surrounds tensions in Europe. The Europeans have really doubled down on privacy protection, big time. And they essentially want European-like protections for data to travel with Europeans, even when they're using American services. And so this is like literally nearing a trade dispute status problem. It's not clear to me how President Trump is going to do this. The way we deal with this now is we say that companies that have large European presence, they agree to a series of rules, European rules, that are enforced by the Federal Trade Commission. Great. But then the problem becomes, if Trump comes in and disempowers the Federal Trade Commission, the Europeans will no longer be satisfied with that deal. And they will call for companies like Google and Facebook and the like to be directly regulated by all the different European regulators. And that would be a difficult thing for our companies. And I just have two more. The FCC's directional shift is very important. The open internet order had the effect of establishing net neutrality norms, but it also was very important for privacy. And what it made it very difficult for Comcast, AT&T, Verizon, and so on to sell profiles about you, well, those rules are going out the window. And this is going to be a very important privacy problem, especially because these carriers are beginning to buy data broker companies. And they want to take your online data and merge it with your offline identity. It's their strategy. if those companies can only be regulated by the FCC, and the FCC basically says, the market will take care of it, the biggest privacy problems are going to come from AT&T and Verizon. And then finally, and this is the main critique of my book, the business community is both litigating and lobbying for a return to common law consumer protection. If you listen to what they're saying, they want the FTC only to be able to take privacy cases where there is economic harm, and so on. And we should be able to recognize this as a return to the 19th century. And so they want to be able to use 21st century technologies. They want to have a regulatory regime based on performance standards and the like, but they want a 19th century regulatory regime. And I think this is a fundamental regulatory challenge that we are facing now in technology. Julie Cohen has a great article about this, and in my free time, I've been writing briefs in these cases, pointing out the historical departure from the common law, the rise of the administrative state, and the need, if we're going to have performance standards to regulate, we're also going to need experts. And we're going to need discretion, agency discretion, to police consumer protection. The best example is VW, right? You take a company like VW that installs software in its fleet so that it can evade emissions testing. Okay, that's a performance standard regulation. VW has to meet certain emission standards and so on. Well, if we move to that type of regulation, we're going to need deep experts in federal agencies to detect cheating and to police that type of wrong. So I went as quickly as I could through my slides, but I still see that I took too much time. So I want to say thank you for listening to such a long presentation. And I'm happy to take any questions about the FTC or the book.
Great, thank you. Time for a couple of questions, I guess. Yes.
Well, so I was wondering a little bit more on the kind of the FTC and the public choice theory.
Yeah.
Because it seems to me a little bit that it's almost like there's, you talk about how it's free from kind of the public choice dynamics. That seems to be at least ex ante, and I'm guessing it's because of its broad jurisdiction that no one finds it worth capturing, essentially, until there's an investigation or whatever, an action directed at them, and then it seems like the public choice dynamics play out as expected on the congressional side of kind of stripping power from the FTC.
So that has happened. So that's happened 3 or 4 times. Congress will intervene and give an entire industry an exemption from the Federal Trade Commission. A great example is with the Packers. Meat Packers got an exemption from the FTC early in its history. The agency itself, however, is it's attacking. It's going after the biggest companies in the field, some of the biggest issues in the field. The employees of the agency are very devoted, and the types of aspersions that you see from like Tulloch and company, that what these guys do is they make regulation really complex so they can go make a lot of money on the outside. It just doesn't seem to be true.
Where does the professional staff of the FTC, like if there is a revolving door there, where do they come from and where do they go?
It's a great question. So what happens to the FTC staff? It's been different at different times. There was a really frequent revolving door in previous decades. In recent times, there's a lot of competition for Federal Trade Commission jobs. In fact, partner-level lawyers, like literally partners from law firms, apply to be lawyers at the FTC. And it's for a whole series of reasons. It's a nice place to work. You have things like flex time. So there's a lot of appeals to it. And there are many lifers. There are many people who spend their whole life there. And then kind of the other aspect of this, if you look at the commissioners, they don't always do so well post-FTC. You look at them carefully and you'll see they bounce around law firms. They're at one law firm for 2 years, another law firm for Because of the ethics rules that they're so broadly prohibited from working on cases that the FTC worked on, that it makes it difficult for them to do client engagements. Yes, Richard.
You may not want to say much about this, but I was wondering if you had any comments about a term of competition law, which you mentioned in passing, and whether the FTC would play a role there or be in some other way.
I think so. So the question is about what is the role of competition law, and what is the FTC likely to do? The specter of competition law and privacy was first raised by the Google DoubleClick merger, and no one really knew what to do about it. Professor Peter Swire was among the bravest people who sat down and he wrote an article about how one might deal with this problem. And then Commissioner Pamela Jones-Harbor made it her kind of career of the merging of privacy and competition law. It is difficult to figure out exactly what to do because of the consumer benefits from having a single platform perform all these different functions. And I think when you look at the landscape, the Europeans are much farther ahead on this issue. They saw this as an issue years before American regulators did, and the best writing I've seen so far on this issue is by Maurice Stuckey.
Yeah,
He's got a fantastic book about big data and competition.
yeah. His book, So I only ask because I got interested in this, and partly because of the teaching in Europe. A lot of interest in the students over there, so I wanted to pick your brain a little bit about that. But that's what I said.
Yeah.
There are a lot of conceptual and political problems about moving forward, even in Europe. So.
No, I think that's right. I think it's difficult, and consumers might ultimately hate the interventions, the standard toolkit of interventions. I think a lot of consumers would not like.
Yeah.
Quick question. From what I gather in your chronology about the regulation of sugar and how that failed, and the FTC shifts over into enforcement and ultimately the internet, right? Privacy enforcement related to the internet. I don't know if I'm understanding correctly that story, but is that accurate recounting of what you just shared with us, that the fiasco with the sugar regulation is what prompted the FTC to move in a direction ultimately that led to the internet kind of enforcement?
It's not necessarily the internet, because the issues surrounding the children's advertising and sugar was resolved in the early 1980s. President Reagan's chairman pushed the FTC away from passing rules. So we had fewer rules out there, and at the time, the FTC was taking on more than it could handle. They had a rule called the funeral rule, which requires funeral directors to give you a price sheet and to tell you things truthfully, like whether you can be cremated. And there was massive problems in funeral practices where funeral directors would basically imply that cremation was illegal. And so you had to buy this $5,000 casket, blah, blah. So they had that rule that was going to rob funeral directors of a ton of money. And then they had a separate rule called the used car sales rule, which would require used car salespeople to disclose all known defects in the cars they sell. Now, so the industry was able to kill that rule. And instead, we have that thing where there's a piece of paper that says whether it's sold as is or with a warranty. They were able to kill that one. But those combinations of rules created such a reaction to the Federal Trade Commission amongst so many strong business constituencies. So you imagine all funeral directors, all used car salesmen, all advertisers are able to come together and say, let's do something with this agency. Among the things they do is they make it more difficult for the FTC to use its unfairness power. and much more difficult to do rulemaking. So the FTC doesn't have Administrative Procedures Act rulemaking. It has something called Magnuson-Moss rulemaking. And as a result, it is so difficult to pass rules that the FTC only does so when Congress tells it to. So when it comes along, when the internet comes along, they say we're going to deal with these problems through enforcement, and we're going to use our deception power, because both liberals and conservatives agree that deception is a normative wrong, whereas unfairness raises issues about what types of transactions we are going to have in an economy, and it looks more like legislation than enforcement. Does that answer your question?
Yes.
Okay.
That's it. Why don't we thank Professor Hoofnagle.
Thank you.